Hello, this is Pooja Sri from Tirthangal College. So now I am going to discuss about the company law subject, which is Introduction to Company Law. So what do you mean by company? The definition of company. A company is defined as a group of people that contributes money or the worth of money to a common stock to employ it in some trade or business. The people in this group share the profit or loss. As the case may be arising as a result, the common stock is usually denoted in terms of money and is the capital of the company. The person who contribute to the common stock are the members. The proportion of the capital entitled to each member is called member share. Shares are always transferable, subject to the restrictions and liability offered by the rights of the transfer share. Now we'll see what are the characteristics of company. Incorporated association, artificial person, separate legal entity and limited liability, separate property, transferability of shares, perpetual existence, common seal. The company may sue and can be sued in its name. So incorporated association is nothing but artificial person, which is going to be the company is an artificial person. It is not a human being. That's why it's called artificial person. Separate legal entity is nothing but they are going to be situated in separate place with the locality that they are going to choose. Limited liability, they will be restricting towards the shares or the volume of capital everyone was going to share for the particular company. Separate property, so the company in the sense they are going to situated very separately and the properties has to be owned by the particular company alone. Transferability of shares is easy. Why? Because the person may come and go but the company will stay forever. So perceptual existence, so it will be always existent. That's why, because the company will be stays or forever, even the person may come and go. Common seal is nothing but a company cannot sign the documents. So the particular people will be creating their own common seal and they are going to give it to the documents by the way of the authority is going to sign. The director of the company can sign and under that the common seal of the company can be stamped. Company may sue if a company is going to be registered on the Companies Act 1956. Now it is 2013, so it is going to register under that. It can be easily sued and can be sued in its own name. Advantages of company. Liability for shareholders is limited. Here the main advantage is liability for the shareholders will be limited to the extent what they are agreed upon. More than that they need to pay for the liability. It's easy to transfer ownership by selling shares to the another party. So easily transferability can also be possible and the shares limit of the liability is limited. Shareholders of and family members can be employed by the company. The company can trade anywhere in the world. Taxation rates can be more favorable. Access towards the wide capital and skills base. Disadvantages of company. The company can be expensive to establish, maintain and wind up. The reporting requirements can be complex. Financial affairs are public. If the directors fail to meet their legal obligation, they may be held personally liable for the company's debt. So profit distributed to shareholders are taxable. This chart represents the types of companies. The types of companies on the basis of members. So members, they are going to have the one person company. Private company, the minimum for the private company is 2, is maximum is 200 members. For the public company, minimum is 7 and maximum is unlimited. Limited by liability. Companies limited by shares, company limited by guarantee and then unlimited. So this case is going to be liability clauses. And special companies, government company, foreign company, section 8 company, public financial institution, these are the some of the special companies. And lastly, control, holding company, subsidiary company, associate company. Holding company is going to hold 51% of shares of the particular company. Subsidiary company, which has been holded by the particular company, is called subsidiary company. Associate company, they're going to work together in one single name, that is called associate company. Lifting or piercing of the corporate veil. So definition of that: the concept of lifting or piercing the corporate will refers to the judicial act of imposing personal liability on shareholders, directors, or other officers of the company for the company's obligation and actions. So, what is the purpose of that? To prevent the misuse of the corporate sectors or the corporate structure for fraudulent, illegal, or unjust purposes. Legal implications: when the corporate wheel is lifted, the separate legal entity principle is disregarded, holding the individuals behind the company accountable. Statutory lifting or piercing of wheel. Doctrine of lifting the wheel: when a company registered under the act, all the dealing with the company will be in the name of company and the members will be disregarded. This shows that there is a wheel drawn between the company and its members. The wheel is partition or curtain between the co and its members. Following this principle, the courts in most cases have referred to go behind the curtain and see who are the real persons composing the company. Example of this case study: Solomon vs. Solomon and Co. Limited, which is 1897 case. So background of this case study is going to be Mr. Solomon incorporated his business as a company and held a majority of the shares. When the company went bankrupt, creditors sought to hold Mr. Solomon personally liable. For the outcome, the court upheld the principle of a separate legal entity, not lifting the corporate wheel. However, this case laid the foundation for the future instances where the wheel might be pierced to prevent injustice. When the wheel is pierced, fraud or improper conduct, which is the example, a company formed to defraud creditors. The secondly, avoidance of legal obligation, using the corporate structure to evade taxes. Single economic entity, which is example, treating a group of companies as a single entity to impose liability. Now we'll see the distinguish between the company versus partnership. Feature and company and partnership. We are going to see like that. The first feature is going to legal status. Company is going to be the separate legal entity, and partnership there is no separate legal entity. Liability of the company will be limited and partnership will be unlimited. So management, who is going to manage this? The company is going to be managed by board of directors and the partnership company is going to be managed by partners. Continuity, perpetual succession, and depends on the partnership agreement. It might be 10 years or 15 years. What they agreed will be continued. Registration. In company, the registration is mandatory with Companies Act 2013. But the partnership, it is optional but with the limited rights. Transferability of interest is going to be easily flexible, the companies, but the partnership that requires the contents or a consent of the particular partners, all the partners. So legal status, separate legal entity. The classification of the company, which is going to be based on the incorporation. Types of company: statutory company, created by a specific act of parliament or state legislature. Example: Reserve Bank of India. The type of company: statutory company. The example is Reserve Bank of India and Life Insurance Corporation of India. Registered company, formed and registered under the Companies Act 2013. For example of that, Reliance Industry Limited. So the types of company, again continuation of that. Companies limited by shares. Liability of the members is limited up to the amount unpaid on the shares, which is the example with the HDFC Bank. Company is limited by guarantee. Members' liability is limited to the amount they agree to contribute in the event of winding up. Non-profit organization and support sports clubs are the examples for the limited by guarantee. Unlimited companies, no limit on the liability of the members. They are personally liable for the company's debt, which is some private firms. Based on the number of members, private company restrict the right to the transfer of shares, limits the number of members to 200 and cannot invite the public for the subscription of their own shares. For example, a family owned business. Public company. No restrictions on the transfer of shares or no limit on the number of members can also be invite the public to the subscription of its own shares. For example, Infosys Limited. One person company. A company with only one person is called the one person company. Example, single owner startup who is going to do all the activities like buying, selling, distributing, doing accounts, managing, everything is going to be carried out only with the help of the only one single person, that is the owner. Based on the controls, holding companies, a company that controls one or more subsidiary companies. Tata Sons Holding, Tata Steel subsidiary. Subsidiary company is a company controlled by a holding company. I told it right. So example of that is Tata Steel and the Tata Sons. Associate company is a company in which another company has a significant influence but not the control, which is called joint ventures. Incorporation process of a company. Firstly, obtain digital signature certificate DSC. The purpose of this is required for filing electronic documents with the register of company. Without registration, nothing can be done. So, firstly, getting the digital signature certificate. Example, application process for obtaining DSC. Step 2. Obtain director identification number, which is DIN number. Purpose, unique identification number for directors. Example, application process for DIN issuance. Third one, name approval. Purpose, reserve a unique name for the company. Criteria for name selection. Application process with ROC, Register of Companies. Fourth one, drafting memorandum of association and articles of association. Purpose, defining the company's constitution and internal rules. Example, contents of MOA and AOA drafting process. Fifthly, filing incorporation documents, which is the purpose, submit required documents to the ROC for incorporation. Example, documents include MOA, AOA, consent of the directors, address proof, etc. Step 6, payment of the registration fee. Fee payment for the processing, the incorporation application, fee structure and payment methods. So verification and approval. Purpose of this registration of with the companies, verifies the documents and approves incorporation. Timeline for approval, typically verification process. Certificate of incorporation. So officially document confirming company's legal existence, issuance of the certificate of the incorporation by ROC. Management and administration of a company. So board of directors is the people who is going to administer and manage the company. So role of the particular board of directors is governing body responsible for overall management and strategic decision. Appointment, elected by shareholders at annual general meetings, AGMs. So functions is going to be decision making, policy formulation, oversight of management. Composition of board. Types of directors will be executive, non-executive, independent. The roles and responsibility of the composition of boards, chairperson, managing director, CEO, etc. Committees, audit committee, nomination and remuneration committee, etc. So meetings, the board of directors meetings will be board meetings, committee meetings. For example, audit committee. The frequency will be regular intervals as per the statutory requirements and company's policy. The quorum and procedures, minimum number of directors required for the valid decision making. The resolution will be, the types of resolutions are ordinary resolution passed by majority and special resolution passed by a higher majority. Filing and compliance, recording and finally filing a resolution as per Companies Act requirements. Thank you.